It's wonderful because I am easily distracted. So we'll get through this. Welcome to everybody. It's a nice rainy Wednesday morning, which is wonderful. And thank you for spending the time to kind of chat about an area, my profession, which a lot of people don't know much about. And candidly, I didn't know that much about until some years ago when I started doing it. I'll start with just a little bit about me, and it's just so you know who you're talking to. I'm a Bay Area native, fourth generation San Francisco. I had a long and very good career in my first career as working in Silicon Valley. So I worked in finance and marketing for a number of Silicon Valley companies, including Yahoo, a number of startups, smaller companies. I partially took that job to stay in the Bay Area. I have a very large and somewhat combative Irish Catholic family in the Bay Area. And about 6 years ago, I started being a trustee for family members. So as I mentioned, we have people all through the East Bay, San Francisco, down on the peninsula, down in San Jose. And if you know anything about families, most families have kind of one or two people that everybody kind of looks at and says, well, maybe they'll be the executor of the will, or they'll be the trustee. And in my generation, I'm kind of it for my family. So the general consensus is that I'm not that bright, but I am trustworthy. So I am the trustee for aunts and uncles and cousins, several Roman Catholic nuns. And I started taking courses on how to do it well. And that was purely self-serving. I didn't want awkward Thanksgiving dinners. If I didn't do a good job of taking care of people's money and their trusts and all that sort of thing. So I took all the courses. And as I started doing it, I learned that I actually enjoy the work. And I started making plans to transition out of my previous jobs. And about 3 years ago, I took the test for California. I became professionally licensed, and I started taking on non-family clients. So that's a little bit about me. I will tell you a little bit about what a fiduciary is. And candidly, if you'd asked me 5 years ago, I wouldn't have been able to tell you because it's not a commonly known role. And I think it's becoming more commonly known and more needed as our population gets older. And a lot of people who moved to areas like San Francisco or the Bay Area maybe came here and don't have nearby family, right? And I'll talk about some scenarios where a professional fiduciary might be appropriate, and some examples that are based loosely on some of my clients without any private details, of course, put in there. But what a fiduciary essentially does is a fiduciary acts in place of somebody else. So when somebody isn't able to make decisions on their own, either because of incapacity or because they've passed away, but they've written out their instructions, a fiduciary will come in and make those decisions in an ethical way, transparent to everybody. A lot of times, technically, a family member can be a fiduciary. So sometimes it can be your child, it can be a niece or nephew, it can be a family friend. I happen to be a professional fiduciary, but there are anyone who takes on that role is a fiduciary. They are financially and sometimes medically responsible for making decisions for the person who set up the arrangement. In California is one of 18 states that has professional fiduciary licenses. And that means the professional fiduciary has to take coursework, a certain amount of coursework. They have to pass, get certified. They have to take a test put out by the state of California. So just like a nursing test or anything else. Once you pass the test, then there are certain requirements in terms of ongoing education, making sure that you don't have any complaints filed against you, those sorts of things. And there's a professional fiduciaries bureau in Sacramento, and they basically oversee all of this. And they make sure that, if there are any complaints, they're investigated. And then if they're found to be true, fiduciaries can be fined or have their license suspended. So similar to the Bar Association run by the state. You'll hear sometimes, I'm going to do a quick sidebar. You hear things like the fiduciary situations where someone is in a conservatorship, like a Britney Spears situation. I always tell people that's a family fiduciary. That's not a professional fiduciary. So if you are a family fiduciary, you're not held to the same standard, nor should you be, because you don't know all about the accounting and all of the ethical standards. But when you hear horror stories like that, they do happen. And I'm not going to say there aren't any bad fiduciaries. There's a bunch of us, so some are. But my belief, and I think it's backed up by the numbers, is that most of the time you hear these horrible situations, it's somebody in the family or a family friend or someone else in the neighborhood who sort of insinuated themselves in and doesn't really have the same level of oversight that a professional would have. So let me talk a little bit about, I always say we help during the transitions. And transitions can be anything. Transitions can be your kids move to the other side of the world. The transition can be you have some sort of medical issue that maybe it's temporary, maybe it's permanent, and you realize that you're going to need more help. Transition can be passing away, it can be death, right? And you have certain instructions, you have things that you want for after you pass away, and you want those carried out to the letter. So there's sort of, I think of it in three phases. The first is advanced planning. And advanced planning is usually done in tandem with it's sort of a team planning event, and that's done with the client. It's done typically with an estate attorney who will set things up with a trust and or a will. And it's often done with a fiduciary. So the fiduciary, it's always helpful when I can be involved early in the process so I really understand the desires of my clients. What do they want, right? And what do they want in all these different scenarios? And the best estate attorneys that I've worked with are very good at sort of seeing all the landmines and asking a lot of questions and then documenting exactly what a client will want in different scenarios. So what would happen if I get sick? What would happen if this? What would happen if that? How do I want this to work out, right? And then all of that gets documented. And that gets documented in a couple of different ways. That usually gets documented, and we'll talk a little bit about the documents that go in, but there's a series of documents, legal documents, and then sometimes, in my case, they are not legal. Sometimes they're not legal, but they are, the wishes of the particular person. So for example, I have clients who are very environmentally minded, and they want things done in a very environmentally minded way. So nothing goes to land, or very little goes to landfill. Things are donated, things are recycled. Charitable money goes to environmental groups. There are other sorts of scenarios that happen that maybe aren't documented in the trust, but that I know because I've had conversations with the client, and I want to make sure that their wishes are carried out to the letter. The second scenario, or the second phase, is often what I call support needed. So all the documents are drawn up, everything's fine, and I have sort of a weird job because I just sort of, in some scenarios, just sort of wait. I'm not needed. I check in with my clients maybe with an email or a phone call maybe once a year. How are you doing? Blah blah blah. I'm still here. But my clients don't need me. The documents are all drawn up, they're ready to go. But maybe something happens and there's some sort of an event, right? There's a medical event, there could be a stroke, there could be a car accident, there could be a number of different things. And in that case, those documents sort of kick in, and I'll talk about what those documents are in a bit. But often either temporarily or permanently, I'm called in to help do things like manage daily bills and financial affairs, work with tax accountants and CPAs to file taxes when my clients can't really do that and pull together all that information. If needed, I can act as a power of attorney for both financial or medical, or theoretically as a conservator. I don't take on a lot of conservatorships, but if necessary with an existing client, then I will, if it's the sort of thing that is determined that that's what the client needs and needs somebody to have that level of oversight and that level of support. And I manage the support team, and I'll talk a little bit about that later, but there's a surprisingly large number of support people and professionals in everybody's life that we don't even think about because we just sort of do it and we're used to it. But when I step in, I often realize there's 15 to 20 people that need to sort of understand what the situation is and know to work with me and make sure that we're all working together for that client's comfort and to make sure that client's wishes are being carried out. And then in the event of a death, I do all of the work to marshal all the assets, work with all the beneficiaries, work with the attorneys and the financial institutions, and then make sure that all the instructions of the trust are carried out to the letter and that everybody involved gets a full accounting of what happened with the money, where it went, make sure that somebody can map up the accounting to the trust document to make sure that what the client wanted is what the client got, and that all the beneficiaries got everything that they were entitled to. The overriding theme of all of this is that I honor the client's wishes in all endeavors. As long as the client's wishes are ethical and legal, it's my job to carry them out. I don't substitute my judgment for them, right? I don't go in and say, oh, I think that whatever, this charitable group that you left money to, I don't like them, so I won't do it. I'm not allowed to do that. I'm allowed to take a look at the trust, to take a look at the documents, and exactly carry out what that client wanted. In some cases, I have to substitute my judgment if I don't know, based on what I know of the client, and I will do the things that I believe my client wished and wanted. Sometimes they call it proxy decision making, and that's what I do, but I don't do it in a vacuum. I do it based on prior conversations on what I know of the client. And again, I don't substitute my personal beliefs or preferences for what the client wanted. I make sure I know what they wanted and I do that. So let's talk about the support team. The support team can be surprisingly big, and it starts with, I always think the big people, the trust attorneys, the banks, the tax accountants, the financial planners, family members. And when I say big people, the people who are every day, really, really involved in the financial and care for my clients. But it can go all the way out. I work with people who are dog walkers. I have, the favorite charities, housekeepers, if the person is still alive, neighbors that often help, have been helpful over the years and want to stay involved to some extent. Therapists, mental health professionals, all kinds of folks who are sort of the support staff, quote unquote, for a lot of my clients. And those clients can be older clients, they can be younger clients, but for the most part, they need all of this sort of, all of these services, and those people who provide the services need to be scheduled and they need to be spoken with and they need to be paid. And that's, kind of what I do. It's, I have, my parents are in their 80s. They live in Walnut Creek out in the East Bay. More and more, my sisters and I are coordinating the different, between the the gardener and the housekeeper and I say the IT service provider. I am the IT service provider for my parents, but some of my clients have paid people that do that. And so it's real work. And I noticed particularly some of my older clients, it can be kind of exhausting for them to sort of manage all of these folks coming in and out and dealing with the scheduling and dealing with the payments. So sometimes I'm helping out simply as a daily money manager. Sometimes I'm helping out as a power of attorney. Sometimes I am dealing with a lot of these people, even after someone passes away, the house still needs to be maintained. All of that sort of thing still needs to happen. So, all right, I promised I would talk about documents, and this is a little bit dry, so forgive me for that, but they're really the backbone of what I do. And they are created by estate attorneys, they are created by the person involved, they're created by me sometimes. And so a trust, which is probably the bulk of my work, is it's just a fiduciary relationship where someone sets up a trust, they are the trustor. That trust contains some assets, and it contains instructions for what to do with those assets. And it gives me, as the trustee, the right to hold those assets, that property, invest them appropriately, do with them to what I need to do to carry out the instructions in the trust. I am often named as what they call a successor trustee. So in a revocable trust in California, the person who set up the trust is also the trustee. They're the trustor and the trustee while they are alive and capable of managing the trust. If they become incapable of managing the trust or pass away, then it goes to the next person who is the successor trustee. And that's, in my case, I would be a professional successor trustee. In most cases, that is a child, a nephew, a friend, it can be a bank if your trust is large enough and you want to go that way. There's a bunch of different ways you can do it. Almost anybody can be named as a trustee. There's some restrictions with financial planners, but most people can be named as a trustee if they agree to do it. I step in certain situations where someone doesn't have somebody, or it's not appropriate, or they're trying to avoid certain pitfalls. And I'll take you through some examples later of that scenario. A will is just a way that people say how they want to have their estate managed and distributed after death. Some people don't have a will, they simply have a trust. The nice thing, and I'll talk later, the nice thing about trusts is they bypass the court, or often bypass the court, so they can be administered more smoothly and more quickly. The California courts are certainly impacted. And if you just have a will and no trust, it can be a very long process held up by the ability to schedule court time. All right. Sometimes people have a will that it's called a pour over will that simply says, hey, anything that has not explicitly been put in the trust, upon my death, just pour it all into the trust. And then somebody manages the trust. Advanced healthcare directive. If I were to tell anybody, anybody of any age, if you had any document that you should be filling out, it's this. And this basically is a legal document that says how you want medical decisions made about you if you're not able to do it. You're unconscious, you've lost capacity, you're not able to make those decisions. What decisions do you want documented in a way that medical professionals and or your medical power of attorney can clearly decide how they want to do this, right? Just a quick prep, California is going to be moving to, I hope, a standardized, very clear medical or advanced healthcare directive, which is, I think, going to be based on the one that Oregon has done. Oregon's done a very nice job of having a clear HCD. Sorry about that. The other one that's very good is Kaiser. Kaiser does a nice job of having a very clear document that's easy to fill out and covers the vast majority of situations. Power of attorney, and that is simply you just authorize somebody to handle matters such as finance or healthcare or both. A power of attorney can be written by an attorney in almost any way. It can cover a broad range of things. It can cover anything as specific as the sale of a particular house, right? Or managing financial investments. They are pretty clear about what things need to be, what the person who is the power of attorney, what rights they have. So that's a helpful thing because sometimes people only need a power of attorney for some period of time. If I don't know, you're undergoing surgery or you have had some medical issue that you are not able to handle your day-to-day finances, it's helpful to have somebody who can go to the bank, who can go to your financial institutions with this piece of paper and say, I have the right to pay bills. I have the right to withdraw money and put it over here, or accept money and put it into here. And then in some cases, people perhaps toward the end of their life just need somebody to manage that, and that can go on for some time, and it's a lot cleaner if the documents are drawn up ahead of time. And then in a slightly more extreme scenario, there's the letter of conservatorship, and that's authorized by, and that's issued by the court. And the court is a county court, so it could be San Mateo County or Santa Clara County or any county really. You have to go before the court. You have to essentially provide information, and you have to show why this person needs to be conserved. And often it's generally a medical issue, but it can also be a mental health issue. There's a whole bunch of different flavors of conservatorship, and they also can be limited. So it's whatever the court decides. To what extent can you handle the person's finances? Can you handle the medical decisions? Those sorts of things. Again, it's typically a family member who does this, but there are scenarios where it is a professional fiduciary who gets nominated by the court and becomes the conservator for that person. And at that point, they are responsible for whatever activities the letter of conservatorship provides for them. So those are sort of the main documents that people will, there's all kinds of other things, and each one of these has their own flavor, but it's helpful to, I think, know what they are so that as I'm talking about some of the examples, we can talk about what they are. All right. There we go. So I'm going to talk about some examples, and we could talk about what they are or why. So the first is, and these are all fictional people, they're not, I made them up, but they are based on what I've seen just over the last 3 years and what I know from other fiduciaries as well. So Emily's 83, she's in good health. She's never married, she doesn't have any children, she doesn't have any relatives in the Bay Area or close relatives. And she's starting to notice that some of her friends are starting to lose their capacity for some of the activities of daily living. Just some of her friends who maybe are a little older than her, and she's kind of a planner. And she wants to make sure that she is taken care of in the scenario if that happens to her. She also wants to make, she has very strong, some very strong beliefs, and she's designated some charities that she thinks align with those beliefs. And she wants to make sure that her assets are given to those charitable organizations. So this one's actually fairly clean. I see this pretty often. And this is true, I think, particularly in the Bay Area, because a lot of people came here to, for their careers. They came to San Francisco, they came to Silicon Valley. Maybe their families are on the other side of the country. Maybe they're on the other side of the world. And just life happened, and all of a sudden they're here, and there's nobody around to help take care of them and to fulfill this role for them. So what does she need? Well, she's going to need an advanced healthcare directive because she wants to document what happens in the event that the doctors need to understand what life-saving things measures to take. And they're going to have to understand what she wanted in different scenarios. So she can fill that out. She's probably going to need a durable power of attorney. Sometimes you'll hear this described as a springing power of attorney because it springs into place when somebody becomes incapacitated. Again, could be all kinds of different reasons, but she wants to know that if she slips and falls and has to go into the hospital and have a surgery, or if she gets hit by a bus, or if she simply has some sort of medical issue that makes it hard for her to carry out her daily living, that somebody that she trusts is going to be making decisions for her. It would be wise for her to set up a trust, and in that trust, she can designate the charitable organizations that she wants to have her assets go to, and in what proportion and how they would get there. She can also, there's all kinds of different trusts. She can set up a charitable remainder trust. There's a bunch of financial sort of instruments that she can set up, but at a minimum, she should set up a straight up trust for if she becomes incapacitated or passes away. And in this case, she needs to designate a successor trustee. Again, she could pick a friend of hers to do it. What I see often in scenarios like this is people pick a friend, which is lovely and works very well until everybody kind of gets into their 80s and 90s. And then the friend either doesn't have the capacity to do it or just doesn't want to do it, right? That it's a bunch of work to do these things. I can tell you personally, I spend a lot of time going to financial institutions, writing letters, making phone calls, providing documents, making sure that things are done correctly and above board. And sometimes folks, my father for a long time was my trustee, but my father is 87, and he's perfectly sound mind, but he has let me know that he has no interest in doing this for me, which is fine, but it means that I need to designate another successor trustee, right? So that's the most common scenario. Someone looks and they say, and then if that's not possible, they will reach out to a professional, and that will either be a professional licensed fiduciary like myself, or in some scenarios, a bank or an attorney. So that's one of the cleaner situations. Oh, and a named conservator. In the case that she might need a conservator, what happens in California is if somebody needs a conservator and there's no family member nearby, the court will appoint one. Some people like to get ahead of that and find a fiduciary or somebody else, and they put that in the document so that the person that they want is named the conservator, if that should ever come to pass. All right, Antonia and Jacob are a little bit different scenario. They are well off, which is great. They've been married for a long time. They basically have a fair amount of wealth in a diversified portfolio, maybe some real estate assets, and they have 3 adult children who live in the area. So you would think, no problem, just pick one of them and they will be the successor trustee. Their concern is that one child is estranged from the other 2. They don't get along. And this is another common scenario. Kids don't get along, or beneficiaries don't get along. And there's almost certain to be conflict if you name one or the other as the trustee, because nobody trusts each other. And it's unfortunate, but that is true. And I have found that unfortunately, death and money do not bring out the best in people often. And you may think that things are pretty good, but then the fissures in the relationships become evident when money gets involved. And so in this scenario, Antonia and Jacob think that if they name any of their children, it's just going to lead to conflict. And that's a concern for them because they want their kids to get along. They want them to be continue to be a family, and they're still hoping for a rapprochement with the children, perhaps after they pass away. So what would they do? Again, some of this is repetitive, but I can't say it enough. Advanced Healthcare Directive, and that they're going to designate somebody in that Advanced Healthcare Directive to make decisions for them. So they pick one or one of their children. Again, durable power of attorney. They can name their children. They can name a professional. Their trust. So they need to think through, in this scenario, what's the best way to distribute their assets to their children to avoid conflict and to make sure that everybody feels like they got their fair share. And that's something they'll work through with their estate attorney typically. So, and then in this scenario, it probably would be wise to name a professional successor trustee. And again, a licensed professional fiduciary or a bank are typically the two main options that you will see. And that is pretty straightforward. I take these on, I get yelled at by everybody. Wading into a messy family situation that often has its roots, 40 years ago is pretty common, and there are landmines everywhere, but that's part of my job. And I don't need to get emotionally involved with any of it because I typically don't know any of these people until I start working on the trust. And I always tell people, I don't have a horse in this race. I'm not favoring one or the other. I don't give more to one person because I like that person and less to another. I carry out the terms of the trust. And you can yell at me all you want, or you can butter me up all you want. It's not going to make any difference. My job is to be impartial and to carry out the wishes of my client, who in this case is the person who set up the trust. I will say it's probably my least favorite of the sorts of situations that I deal with. Nobody wants to wade into family conflict, and nobody wants to be in a meeting or a phone call where any little word can set off the conversation of, whatever, you broke my toy when I was 8 years old, and so I should get more money. And you'll hear crazy stuff here. This is where you'll start getting scenarios where people will do things that are not in their financial or emotional best interest, simply to win. This is where you hear the horror stories of people with multi-million-dollar estates and trusts, people getting into fights over a floor lamp that everybody needs to have for whatever reason. And there are some tricks for dividing up property like that in a way that is fair. And professional fiduciaries know those tricks and will do it. But it's still contentious and can really be an emotional drain on both the family and the professional who's dealing with it. But in the end, it's probably less painful and less of a drain than if a family member were trying to be the impartial judge, because that's a hard role to step into. Okay, this is a little bit different, and I don't know if anybody on this call has anything like this, but I thought I would cover it anyway. So Sarah and Rebecca. So Sarah, 61 years old, she's a widow, and she has a daughter, Rebecca, and Rebecca's 20, but she has some developmental disabilities. She can work periodically when she's doing well, and she can mostly take care of herself, but sometimes she's living in a group scenario, or sometimes she needs additional support that a lot of 20-year-olds would not need. She probably has a team of caregivers, medical professionals, maybe mental health professionals. And this can happen for both physical people who have physical issues or mental health issues, right? And there's a lot of people out in the world who, for whatever reason, day-to-day living is a challenge, and they need some additional support, and that's great, that's fine. But Sarah's concern, and this is true of every parent that I've ever met who has a child with a developmental disability or a mental health issue, is what's going to happen to that child if I'm gone, right? And so, again, sometimes family members are called in, but it can be quite a burden for some. You know, I have people who will say, well, I thought of asking my other daughter to help, but that's a lot for her because she works and she has a family, and that's a lot for her to take on. So when I speak with them, I'd say, okay, again, advanced healthcare directive, not just for the parent, but for the child. Durable power of attorney, again, for both parties. How you know, who's going to kind of make decisions for these people in the event of some sort of illness or accident. Setting up the trust. So in this scenario, there's a couple of different things. So often I see a family trust where assets are sort of distributed to whomever the trustor wants them to be. Maybe they're charitable organizations, maybe they're other family members, that sort of thing. And then what is called a special needs trust. And there are attorneys, very good attorneys here in the Bay Area, who specialize in special needs trusts. And they are for the benefit of, typically for the benefit of a child or an adult child who needs some additional support and might be on public disability, supplement, SSI, might get some state funds for some of their support needs. And a special needs trust is a tax smart way of setting up an additional fund for this person's care and what they need. It's a rapidly moving target. It's a changing thing because the state legislature changes things every year on what is allowed and what is not allowed. In fact, they just made some major changes, which I think are good changes to allow people some additional funds and some more flexibility. But it's very difficult for a family member to administer a special needs trust because of all the rules and regulations around it. And so a lot of times you will get families naming a successor trustee to manage that special needs trust. And if you're interested, I can walk you through. There are definitely some fiduciaries that this is their specialty. This is what they do. And it's a very helpful thing for families who are in this scenario. All right, the Achevaria family. And I named them that because that's a Basque name and I'm half Basque. So I get to pick the name. So they've been in San Jose for generations. Over the years, they've built up a kind of a little stable of businesses and rental properties. Some are successful, some are less successful, but they are entrepreneurs, and this is what they've done. The problem is that the current generation of the family has no interest in running all of these things. They either have their own careers, or they live somewhere else, or they simply don't have any interest in being business people. So the patriarch and matriarch of the family need to think about how to set this up. And so they have decided that they don't really want to sell the businesses for whatever reason. Maybe they don't think they're going to get full value for it. Maybe they think that the subsequent generations might want to have a business to run. And they want to set up a trust where the income from the businesses is distributed to the beneficiaries. And what does that mean? Well, I'm going to run through these first three pretty quickly. The Advanced Healthcare Directive, the Durable Power of Attorney. But in this case, the trust is going to be interesting, right? In this case, the trust says, I want somebody, the trustee, to manage these businesses, right? And you can hire somebody to do the day-to-day, but I want somebody who is going to overall coordinate, just like a family member would do, and deal with these businesses, take in income, pay bills, pay taxes, deal with all the legal issues with running a business, and then based on the income generated, distribute that income the way that the trust says to distribute the income, right? So the most common thing I see here are rental properties. So in that case, I, as the fiduciary and the trustee, if this is the scenario, they say, we don't want these sold, then what I'll do is I'll work with property managers who do the day-to-day of maintenance and collecting rent and dealing with people who don't pay and all of the stuff that makes being a landlord somewhat painful. But then, and those people get paid as part of the cost of running that business or running the rental property. But then the fiduciary would basically consolidate that with any other income, including investment income and other sorts of things, and distribute it to the beneficiaries on an annual or semi-annual basis, deal with the tax ramifications of doing that, account for everything so that everybody sees where the money came in and went out, and then depending on how long it goes, do it again the next year. So those are, this is sort of a different scenario where your fiduciary, what you're going to want is someone who has some sort of business sense, who isn't just accounting, pulling money in and out, but can deal with contracts, can deal with understanding the market. If it makes sense to sell at a certain point, to work with the beneficiaries to decide when is an appropriate time to sell. Sometimes the trustee has some latitude on making good business and financial decisions for the benefit of the beneficiaries. All right, I'll skip through this. I spoke really quickly about will, no will, and living trust. No will is the most painful, where it goes to a no will go to the court. The court will appoint somebody. It's expensive because you have to pay that person that they have appointed. You're gonna have to cover court costs and attorney fees, and it can take a long time. So at a bare minimum, people should really consider having an updated will that is easily discoverable, findable by your heirs, and deal with that. A will still will go to probate court. It's still overseen, and documents must be filed with the court. So a will with no trust still has some of the pain. It will, and a will doesn't do anything for you before you die. So it doesn't say what would happen if you're incapacitated or you simply need some additional help as you get older. And there's no privacy if anyone cares about that. All the records are filed with the court, and those are open to people, basically. The living trust or the revocable trust is the one that I've been talking about. That does a lot of nice things. It avoids having to go to court. You get to specify who's going to manage things. You get to specify in detail how you want your assets distributed. You could put instructions in there for before you pass away, if certain things need to happen, if you're incapacitated or just are tired of getting. The nice thing is you're always in control of all of this, all your decision making, all your assets as the trustee until such time that you are unable to do that. So you don't lose control of your trust simply because you set up a trust, this separate legal entity. All right. So I always tell people, if you just want a shorthand for what a professional fiduciary does, we do what family or friends would do for you if they were local, had the time, skills, and a roster of trusted experts, tax people, medical people, all that sort of thing. So it's not that different, right? There's a reason that I do this for my mother and father, because I can, I'm local, and I'm willing to do it, and I have the background that allows me to do it. Not everybody has that. Just life, as I mentioned, life happens, people end up Maybe you have somebody that would fit all those pieces, but just tells you, I just have too much on my plate. Like I'm swamped doing these other things. Please don't ask me to do that. And, and again, I mentioned the situation where there's contention in the family and people simply say, I don't want to do that because I'm just going to have to deal with my sister and we've never gotten along and whatever I do, she's going to hate and it's just going to be miserable. Can we have someone else do that? So that's kind of what it is. So some resources for you, and this is, I think, going to be sent out and also posted up on the Avenidas website, so you don't have to write any of this down. But Professional Fiduciary Association of California, PFAC, cleverly named PFAC. It's a good group. It's a very good group of people that are, I've been very, very impressed with the level of professionalism and dedication and ethics of the folks that are a member of the association. And also it's a great place for people to share information back and forth. I always tell people a good professional fiduciary is a mile wide and an inch deep, right? We know a little bit about a lot of things. We don't often know a lot about any specific thing. So, most of us are not experts in, trust tax law or, medical equipment, where to get the best medical equipment, all those sorts of things. But PFAC is a great resource for finding out that level of detail for us. For consumers or for clients, the best thing I think on there is the fiduciary search. So you can go onto their website to that fiduciary search link, and you can look for fiduciaries in your area. And you can ask for people who speak a particular language. You can ask for people who have a particular expertise in some area. You can ask for people who are generalists. So I think that's really helpful. You should know there's not that many professional fiduciaries. I am license number 1200, which sounds like a fair amount until you realize that there are 40 million people in California. And so, when you go in there, take a look, don't filter too much, because if you go in there and you say, look, I need Cantonese speaking fiduciary who is also an expert in real estate law, you're probably not going to find somebody like that. As I mentioned, most fiduciaries are generalists who have a roster of experts that they rely on for really detailed things. The second is, whoops, I'm so sorry. I went, the second is the California Professional Fiduciaries Bureau. This is the licensing bureau. It's another way for you to take a look. You can use that second link for license verification, making sure that somebody is licensed, that their license is up to date, and that there haven't been any upheld complaints filed against them. So this is where you could take a look and they say, oh, well, so-and-so was fined in 2017, and this is what the fine was for, right? So that gives you some indication, I hope, of, pro tip, you probably want to look for people with no upheld fines against them. Or if there is maybe one, it can happen. Sometimes you will get an issue in there where it is a procedural issue. So you didn't file something with the court in the correct format, and the court didn't like it. So I'm not going to say if you had one or two of these, over the course of a career, that you're a bad fiduciary. You might be really good. It's just that you're filing, hundreds of different documents with the court, and maybe you did something and didn't do it in the correct format or the way the court liked it. So that can happen. But that being said, if you see somebody in there with a bunch of them, you should be cautious. All right, and that is it for me. And I took a little less than an hour, and I see there's a big chat. Should I stop sharing?
Yeah, you could take the You could take, can you hear me, Pablo?
I can, yeah.
Okay, it's Paula. Hi, everybody.
Hello.
So I would say, yeah, go ahead and take that down, and Sam and I and you should be on screen now.
Got it. Okay.
And we've got a lot of variety of questions here. So so stay on,
Sure.
everybody, and we're going to go through these questions. So Sam, are you ready to start with the question? Do you have some questions prepared from the chat?
Give me 1 minute.
Oh, wow. I'm looking at the chat now.
Yeah, I can
All right.
start.
I'm going to do my best.
So Robert Shaw, who I do know and I've talked to many times, he's very involved with a lot of our presentations and always asks great questions. So I'm going to actually combine some of these questions because some of them are repetitive. So Pablo, how do you want to distinguish? This is about the role of the durable power of attorney. And I think people need to understand that the fiduciary can be assigned these roles or not, and that you can also work with the people who are pre-assigned within the family. But the question is really to clarify the difference between what each does. So the durable power for medical and for financial. And I think it's confusing because the medical one is now kind of housed in the advanced directive. But I think when we talk about DPOAs, we're talking about the advanced directive / medical. So they want to know what are those roles are. And then if somebody wants to rescind the role, how do you do that?
Sure. So that's a very good question because it can be configured in a number of different ways, which is helpful, but also confusing sometimes. So as I mentioned, a durable power of attorney can be written for financial or medical concerns, and they are customizable. So they're written by an attorney. An attorney can write in whatever the client wants, right? So I've seen durable power of attorney, or I've seen durable power of attorney that like limits people as to what they can do. Some are very broad and allow you to do almost anything with the person's finances. Within the Advanced Healthcare Directive, somebody is named, and I don't know, I'm not a lawyer, so I'm not going to give legal advice on this. I don't know if that technically makes that person a power of attorney. I know it gives them the right to make medical decisions. I am often working with a family member or friend who has been named the durable power of attorney for medical issues, and I am named for the financial issues. That's the most common scenario. In some scenarios, I'm not named as either. The person says, I just want you to be the professional trustee for when I pass away. During my lifetime, I want this person to be my power of attorney for medical and financial, and they're willing to do that, and they can do it. They can be rescinded, and a power of attorney can resign as well. So a power of attorney can come and say, I don't think I can do this for whatever reason. I have to take a job on the other side of the world. I'm not capable of doing it, or I just don't want to do it anymore. So yes, you can, or a person can say, I no longer want that person to be my power of attorney. I'm going to draft a new one that names a new person and expressly takes the other person off the power of attorney. Is that helpful?
I want to add on to this because I've had this happen with some clients during COVID. So I've had a client who became incapacitated, was hospitalized, and had to be conserved because she had no one set up, but she had a few people assigned certain roles, and then those people did rescind because it was too complicated for them to continue working with her. Since she was completely confused. So in order to rescind, usually what happens is you write a letter and you send it to the person, or to, if you know, their attorney, or to somebody involved with that person. But it's always good to document that you're rescinding. One does not want to take on or accept the role of being a DPOA unless they're really committed to doing it, because if you rescind at the last minute, then it makes it very difficult, especially for somebody who's in that process of becoming confused, to do anything else other than end up being conserved. So I just advise people to really think carefully about who they're assigning and that they trust the person and that they're committed, or not to take on the role if you feel that you cannot do it 5 years, 10 years out. I think that's part of the issue. And then on most of these forms, there's 3 options. You know, you have your first, second, and third choice. And a lot of us are now thinking about a younger person we know who would be willing to sign on, who's in our family or trusted, or the children of trusted friends. Okay, so Sam, let's move on. What's another question? You've got one ready?
Yes, I received a direct message question. I won't say from who, just for privacy things, but this person asked, are contracts signed between fiduciaries and clients? If so, are there provisions for handover to someone else? For example, if the fiduciary retires, also, what is the usual payment method?
Sure, that's a good question. There are contracts. I have a services agreement that I ask my clients to sign. That does not make me a power of attorney or a trustee. Those have to be in the legal documents in the trust or a separate durable power of attorney contract. Mine is simply for payment, right? It just says if I act in this capacity, this is how the payment will go and whatever. Second question, if I retire or go on. So that's a very good question, because what happens in that scenario is I can refer my clients to another fiduciary. I cannot simply hand them over, right? The trust documents and the power of attorney contracts are between me and my client. They're not transferable to somebody else. So that is something to be aware of when you're signing people on. So I could retire, I could get hit by a bus. If you find a younger fiduciary, they could retire, change careers, or get hit by a bus. So what you really want to do in those scenarios is, to what Paula said, is to have a succession plan within your documents. So, you know, I name Pablo O'Brien fiduciary as my successor trustee. In the event that he cannot or does not wish to perform his duties, then I name, Sue Adams as my trustee. And then usually you want to have like 3 of those as a backup. Some people will have, and you could talk to your estate attorneys, you will then say, some people will say, if I've run through all of my list, then my attorney at such and such has the right to name a successor, a professional fiduciary as a successor. Most estate attorneys work with professional fiduciaries. We have a working relationship back and forth, and they have sort of a roster of people that they can name. How do I get paid? Quickly, if I have anything to say, but but usually it's not quickly. It's a profession that you wait quite some time for your money. So the way I work is, if I'm helping somebody while they are alive, if I'm working as a durable power of attorney, as a conservator, as a daily money manager, which is another thing that I do, I simply help people pay their bills, and I show them, the accounts at the end of every month. If I'm working as that, I work on an hourly basis, right? And I have a flat fee. I charge $150 an hour for any of those things, right? If I am administering a trust, then I take a percentage of the trust assets. So depending on the size of the trust, it's a sliding scale, but it's anywhere between 1 and 1.5% typically of the trust assets. And that's a pretty standard fee, both for probate. You'll see that's within the California probate code, and managing trust.
I have a question that came in at 11:39. So Sam, I'm going to kind of, I've gone back into the Q&A, and I'm just starting with like the first question that appeared, and then I'm moving through time. So I'm at 11:39, Richard. So Pablo, he's asking, because you mentioned dealing with siblings that are having a conflict, you mentioned that you have a way of helping them divide the property even though they're not very cooperative. So is there a scenario you can share? He wanted to know what are some of your strategies for working with siblings and being able to divide property when people are in conflict?
Yeah. So the simplest thing for me that I've found is identify the things that are in question. So if you go into anybody's house, it doesn't matter if it's even a small apartment, there are a lot of things, most of which will, as a trustee, I will either donate, in some cases sell if they have value, or just take away, right? There's recycle as much as possible. But if there's a set of things that the beneficiaries are arguing about, and they're usually a fairly small set, then what I'll do is I'll identify each one of them. And I will do one of two things, depending on how complex the situation is. One is a simple lottery with allowing people to, pick out of a hat, or I pick their names out of the hat, and it says, Jane gets to pick first, John gets to pick second, Mary gets to pick third, and then we cycle back up right through. And it's a little bit like a sports draft, right? Where it's just the luck of the draw. Whoever got first gets to pick it. I'm not open to arguments about, mom loved me more, and so I should get the teapot, right? Or whatever. The second, depending on how complicated the situation is I will allow people to bid on things. So I will say, you get 1,000 points. And here are the 8 items that are at risk. You submit your bid for each item totaling up to 1,000 points. Submit it to me, and the high bidder for each item is going to get the item. And that's a way of sort of indicating how important certain things are. So some people might come in and go, I'm going to put all 1,000 points on whatever it might be, right? That piece of jewelry that mom had. And so that's the most important thing to me, and that's what I'm going to bid on. And others might say, well, that wasn't the most important thing. I want it, but the most important thing for me was, I don't know, I've seen everything, right? This toy from my childhood that she kept. So there's different ways of doing it, but the key for me is that whoever's managing that process is impartial, doesn't have a horse in the race, and that the distribution is based either on just sheer luck or somebody's willingness to bid their points.
I'd want to add to that, to people listening, that what's really helpful to do is a lot of proactive planning and discussions with family prior to actually even hiring the fiduciary,
right,
and trying to learn where you do have differences. So there are family mediators who help with this process, because when there is a crisis and there is a transition, and when Pablo talked about transition points, those are usually involving some sort of crisis, you really don't want to have your energy spent in this kind of way. So proactive planning and having these difficult conversations, even about medical treatment and options for your care, is also really important, along with dividing up and looking at the inheritance, and then the art objects or the objects in the home. So that's my plug for proactive planning. Okay, I see one. How is a fiduciary different from a fiduciary financial advisor who gives advice, and maybe it's not making decision making? So that's a question for you. Is there a difference between a fiduciary and a fiduciary financial advisor?
Yes, and it's a confusing terminology. I completely understand the question. I still get myself tangled up in it. A lot of financial planners will say, I have a fiduciary duty to my clients, and they do, right? Their fiduciary duty is different than mine. It's a more narrow fiduciary duty. It has to do with the assets that they have under management and what they are allowed to do and not do. But they still have a fiduciary duty in the sense that they will make financial decisions for their clients with the assets they have under management. They do not have the right to make financial decisions about your house, about paying bills, about any of the paying taxes, about any of the other scope of your financial life. It is confined to what they are investing for you, right? Or they're giving you advice on, and they're obligated to give you advice and management that is in your best interests, not in theirs, right? And that makes them a fiduciary. It's a different thing. They're licensed differently. I work with investment professionals all the time, and with some really good ones. And it's more of a complementary role, right? Where I manage a certain part of my client's financial life, and the investment advisor manages, their specific part of it.
Okay, Sam. Trevor.
The next question says, do LPFs handle liquidating tangible personal property such as real estate, livestock, art, cars, etc.?
We do, yeah. And typically, that's a pretty common thing, right? So in the Bay Area, what we find is that a lot of people have quite a bit of their financial worth tied up in their homes, simply because of the real estate run up in the Bay Area over the past 40, 50 years, some of which is reversed in the last 6 months, but some of it. And so, that's pretty common. So at the moment, I am selling a house working with a real estate professional, but clearing out and selling a house because none of the beneficiaries want the real estate, they want the money. And they don't live here, so they don't want to deal with that. So I am dealing with the house. The same is true for anything. It can be cattle. It can be, I've seen toy car collections. It can be collections of figurines that have some financial worth. A lot of times unless somebody wants those tangible assets and they have the right to those tangible assets, the most common scenario is that the fiduciary will liquidate those at the best possible price and then distribute the cash in the way that the trust says to.
Okay. So I'm going to thank everybody for staying on. We have 10 more messages, and we're going to get through them, and we can keep going as long as Pablo's willing to be with us. So this is a kind of a very broad question, and maybe you'll come up with one or two situations. So this person wants to know, just what are some of the common situations where people get into conflict of interest in a situation or with an institution?
So if I understand the question correctly, when I say conflicts of interest, let me think. So let's say you have a non-professional fiduciary who is also a beneficiary, right? And you will get a scenario where that person their job is to distribute the assets of the estate according to the trust or according to the will. But you can easily imagine a scenario where they say, well, I'm doing all this work, so I should get first crack at pick something, right? Some tangible asset. Or I've seen scenarios where people are like, I'm going to take the car. It's a very nice late model Mercedes, but I'm going to pay the estate for, I'm going to pay the trust for it, but I'm going to pay them at the very bottom of what that car is worth, right? And the other beneficiaries say, well, that's a conflict of interest. You're getting, a beautiful car for, 50% of its value on the open market. And that car should have been sold and the profits distributed to everyone in the family. You'll see sometimes people will, a very common one is you will see someone who says, well, I'm going to use my own, I want my own real estate person. And it turns out that real estate person is my daughter, right? So the real estate fees sort of stay within the family, right? And unless everybody has agreed that that is okay, which sometimes it is, but unless everybody has agreed that that is okay, you can imagine a scenario in the Bay Area where, let's say it's a $2 million home, 6% real estate fees, that's, $120,000. And the rest of the beneficiaries go, well, wait now, right? Nobody agreed. Was she really the best person to do this? So you will see that. You will even see it sometimes in professional fiduciaries, and we get this drilled into our head all the time. And I'm very, very careful about this. I have a son who is a nurse practitioner in gerontology. Yeah, he's really good at I think he's really good at what he does. I'm very proud of him. I'm probably biased, and I probably should not assign him to work with my clients, even though I think he might do a good job. Caesar's wife, what was it? Caesar's wife must be above suspicion, or the appearance of suspicion. Like you shouldn't have a thing where people can kind of scratch their heads and go, that seems a little weird, right? It feels like there's a conflict of interest there. And you get into them, you'd see that with both professional and non-professional trustees all the time.
Pablo, I think one that's very common for a lot of people when they're blended families or more than 2 or 3 siblings is that if we have an aging parent who's no longer making a decision, and there has to be a decision made about, do they stay at home, do you hire caregivers, or do you go into a care community institution, you're going to get different responses. And this is unfortunately true, but sometimes certain members of the family are worried about their inheritance being spent on the older person's care. And then there becomes a conflict of interest within the family about how the money is used, whether it's used really wisely for that person or kind of saved for the inheritance. And that's sometimes where if that is a family situation you are in, again, the proactive planning is important, but also maybe having an objective person like a fiduciary involved with decision-making for the interest of the person. And that is a very common situation.
Yeah, I run into that every once in a while, right? Where the decision, I think the best decision for my client is, and I'll just pick a scenario, like we're going to sell the house and you're going to go into a wonderful assisted living facility that's expensive, but provides really high quality care. And I will have family members sort of dance around, because nobody wants to say it out loud, but they'll dance around how much of mom's money are you spending on this? And my answer to them is, it's her money, right? This is not anybody's money. It's her money. And it's being spent for her benefit, and that's how it should be. Right. And if there's money left, then and you become the beneficiary, then it's your money. But at this point, none of it's your money.
Okay, Sam, do you have another question?
Yeah, we have a couple of questions related to this, and I think you've addressed this a little bit already, but maybe just a quick summary as a reminder of how you determine your fees and how you charge.
Sure. So like I said, if somebody is still, if I'm not administering the trust directly, if I'm working as a power of attorney or a conservator or a daily money manager, I charge a flat fee of $150 an hour. There's, little bits and pieces in there in terms of travel time and that sort of thing, but basically that's what I charge. If I'm administering a trust, then I take a percentage of the trust assets, and that can range between 1% and 1.5%, depending on the size of the trust.
Okay. I'm going to go to 1156. This is a really important question. I'm named successor trustee on mom's trust, and she is now incapacitated. She has Alzheimer's. How do I actually implement becoming successor trustee?
So that is, you would work with the attorney, if you have an attorney, In some cases, the cleanest is to work with the attorney who drafted the trust. They will draft papers to make you the durable power of attorney. If your mother has capacity and can agree to it, she would sign the papers. If she does not, then you would have to have a doctor's, there's a form, and I think in California, you have to have 2 doctors, if I recall, that will certify that your mother no longer has capacity to make these decisions, and that you're being named as the durable power of attorney.
Pablo, I'm going to join in here. So this happens a lot. And again, it's when things kind of go on for too long and the family hasn't worked with the person while they have capacity to set up a good process of legal documents so that we know if you're diagnosed early with dementia, Alzheimer's, you can still have capacity for quite a while. So
Sure.
that doesn't automatically mean you lack capacity, but that is a point in time when you really, once you get organized and get all the DPOA signed and have everything done, so you don't have to go the route of the expensive conservatorship. So I'm not sure in this case what would happen. So if this person is taken by the family to the doctor, neurologist, and evaluated, and you can call me and I can help you with how to get that done. There's also a free program through the Stanford VA Alzheimer's Research Center that will evaluate a person for capacity and give you the 2 letters. But then you take those 2 letters to an attorney, which if the person already is lacking capacity, you're going to have to consult with the attorney about whether or not you can change anything from the past or add on to it. So this is where it gets complicated. And it may have to be that that there's some other route to go and that there does have to be a conservator name. So this is the exact scenario you want to prevent from happening, because there are some unknowns here.
Yeah, it can get a little messy, and sometimes the court needs to be involved in terms of approving the appointment. And it can be done, but it is certainly a lot cleaner and easier for everybody involved if it's done ahead of time rather than after the fact.
But this particular case, it says you're already named successor trustee. So I don't think that would change. I think what we're talking about is decision-making while the person is alive and they go from having capacity to lacking capacity, and who had been, if you've already been pre-assigned the durable power of attorney, then you may need those 2 letters to activate that. But this is most problematic, not regarding a trust or a will, which goes into impact when the person is deceased. These are questions that come into play while the person is still alive, and decisions have to be made about their life, their treatment, housing, those kinds of things. Okay, so Sam, what's the next question?
This one is asking your opinion on using estate planning docs from sources such as LegalZoom for super simple estates.
Oh, okay. Again, I'm not an attorney, so take everything that I say with a grain of salt, please. So I've used LegalZoom for documents for contracts. They have good, clean sort of templates to work with for certain things. I think the biggest value of an estate attorney in these scenarios over something like a LegalZoom or I forgot the name of the other one, but is that a good estate attorney is an experienced estate attorney, has seen enough of how these things play out to make you plan for a variety of scenarios, right? They really kind of force you through a question and answer process that says, well, you don't think that this is going to happen, but if it did, what would you like? What happens if your child predeceases you? How do you want that to go? Do you want that to go to their issue, to their children? Do you want it to be divided up amongst the other children? What happens if this? What happens if that? So although I think LegalZoom and others certainly have their place, and if you have like the world's simplest sort of scenario, you could do it, right? That I think they're legally binding trusts and contracts. I do think that you know that it's helpful to, I think, a professional a state attorney, their value is not necessarily in like being able to write a trust. It's to be able to walk you through that process and provide their experience on all the pitfalls that can happen and help you to avoid them. My 2 cents. I mean, honestly, if you take a look at the many of the estates in the Bay Area, especially for people who own property, the cost of an estate planner, which can feel like a lot of money, is, you know, a tenth of 1% of some of these trusts and estates, 0.5%. It's, you know, probably almost always less than that. And I don't know, I personally sort of think it's money well spent, but people might have a different opinion on that.
Okay. So Pablo, I think people are confused about that somehow your service is county-based. They're asking, do you serve both San Mateo and Santa Clara counties? Oh,
yeah, I go across counties. They let me cross the border without it checking on me or anything. So I work pretty much Santa Clara, San Mateo County. I have some family stuff over in Contra Costa County. I often avoid I have a couple of people I work with in San Francisco. San Francisco, like in many things, has its own special flavor of court. But no, I do work in San Mateo and Santa Clara counties.
So fiduciary is not a county. It's not, there's no county limitation as to your being a fiduciary, correct?
Correct. The only limitations, honestly, is my willingness to drive long distances to deal with to work with clients. And
okay,
you know,
what about state? What if somebody's in another state? There's a question about if they have relatives in another state, do they need to hire a fiduciary in that state or in that county? I mean, I would think yes, because
I would recommend yes for 2 reasons. One is if it just helps to be on the ground in any scenario, whether you're working with someone who's still alive and needs support, you want to be there, you want to check in on them. You want to be able to look all of their providers and support staff in the eye, know who they are, call them up. If you're managing a trust or estate, it's often you've got to deal with cleaning out a house, selling different things, maybe managing rental property. It's just really hard to do if you're not within a reasonable driving distance of those accounts.
Okay, thanks. Sam, you got a question?
This question is asking if there is a minimum size of estate needed to be able to afford a professional fiduciary.
There isn't. You know, I candidly, I sort of look at 2 things. I will either work, if it's a smaller estate, I will work on an hourly basis. Typically, if it's a larger estate, you know, larger estate, and by larger, I mean sort of like 2 million and up, then I'll work on a percentage basis. You know, different fiduciaries will have different cutoffs, so don't take mine as where people are. But you know, it is a surprising amount of work and a surprising number of hours to do it properly. And sometimes if it's a smaller estate, the percentage of the smaller estate just doesn't even cover, you know, my costs.
Okay, I'm going to find a few questions about, again, it's about the types of things that you might take on, you do, which has, there's a group of questions. So do you help clean out a home, sell the home? If you do sell the home, do you choose a real estate agent and that whole process? There's a lot of questions about that, the type of services you do towards the end of a person's life. So if the house, the articles need to be sold, real estate, are you the decision maker for all?
Yeah, I'm the decision maker. I mostly will not be the person putting things in boxes. But yes. So for example, I have a home right now that's in Woodside. where I'm working with somebody to clean it all out and stage it for sale. So we're cleaning out all the things, we're shipping the things to the beneficiaries who have expressed an interest in having those things. Luckily, in this case, to Paula's point earlier, the lady who set up the trust was very specific about who got what. So the crystal was to be sent to somebody, and the car was supposed to go to somebody else. Super helpful. So I've hired someone to come in and do all that cleaning up, boxing up, shipping to the appropriate beneficiaries, clean the house. I've hired a real estate agent who's familiar with the area and who is also familiar with trust sales, which have some special flavors in California. You just have to know all the additional documents you need to file and that sort of thing. So she happens to have an expertise both in the geography and that type of sale, and she's been a real estate agent for 25 years. And so I'm sort of I don't want to say the ringleader, but I'm the person who will sort of pull in all of these various experts to do this. Some of it I do myself. I mean, I've been out, replacing the pipe on a pool pump, simply because, the pool maintenance people couldn't get out there quickly enough. But mostly that's not my jam. Like I can't be an expert in every single one of these areas. My job is to make good decisions that maximize the benefit for the beneficiaries.
Okay, thank you for that. Okay, so we're getting close to 12:30. Pablo, can you, or I don't know if it's on the chat line, but can you tell people how they can contact you? So we have questions, but I think at this point we'll ask people to contact you. I know you're willing to give people some time on a phone or in an email.
Yeah, happy to talk with people. I don't charge anything for when I'm talking because I just like to talk. So I'll put in, should I put it in the chat?
Why don't you put it in the chat, but that would be great.
And anybody can go to my website, which is southlaurelgroup.com. The name of my company is South Laurel Group. Oops. And I'm probably bouncing all over the place because I've got this thing up on a little platform.
And I just want to reassure everybody that you are welcome to contact myself or Sam through Avenidas. Our line, the main line to Avenidas is the 650-289-5400. That will get you the front desk. You can ask for care partners. They will send you to us and we can go over some of this material and refer you to Pablo. Pablo and I do have mutual clients. I want to disclose that. And I am somebody who does, I'm part of a team for my clients with their attorney, with their doctors, with a fiduciary. And it was through working with Pablo initially, that's how I got to know him. And then I felt he would be a very trustworthy person to come on and talk about this role. I appreciate the fact that he came to it after having another career and then experienced family issues, which is how a lot of people end up in elder care because we want everything to be better for older adults. So I want to say thank you, Pablo, for today. And what we're going to do, everyone, is we'll post this in a few days on the website. We'll send out a survey and then I'll talk to Pablo privately. I do have a copy of the PowerPoint. It's without the dialogue. And if he gives me permission, I can send the PowerPoint out. So you do have that as the reference. Sure. But the actual recording will be posted on the website. And some people watch these on the website and then they kind of just quickly go through for the points of interest that they want. But if you only want the PowerPoint, I will talk to Pablo about that. And we have your emails through your registration process, then we can send it to you. So Sam, thanks for today and for helping out with this. And I want to thank Jess and everybody. Avenidas is open. So if you're feeling comfortable and you want to come say hi and check out our classes and see what activities are starting to take place, please come visit us at 450 Bryant Street. Okay, everybody, thank you so much.
Thanks, everybody. Appreciate it.